Ladies and gentlemen, welcome back to the Indie Zone podcast. My name is Kathy. We had previously reported to you in a prior episode of our continuing podcast entitled Idaho v. Kohberger that the case summary page indicated a notation of May 22nd, 2025, amended notice of compliance. And we had thought that this might have been compliance with the court's order of May 15th, 2025, directing both of the parties to submit information for in-camera review related to a myriad of evidence and information that was apparently provided to the mass media by someone close to the case, notwithstanding the existence of the non-dissemination order. This amended notice of compliance, which has now hit the docket, does not relate to compliance with the court's order of May 15th, 2025, directing both sides to produce this information under threat of sanctions, including contempt of court. It is the state of Idaho's amended notice of compliance that the state has lodged a log spreadsheet identifying which defense exhibits the state is objecting to and the basis of the objection, and those to which there are no objections, all pursuant to the court's October 8th, 2024 unredacted sealed order, further criminal proceedings and notice of trial setting. However, while that order is signed on the 8th of October, for members of the public who want to find it, it was not docketed until October 9th, 2024. So to look at that order, you will need to go onto the court's docket and retrieve it October 9th, not the 8th, 2024. This filing continues. The parties met on May 8th, 2025 to determine objections to exhibits. The state inquired regarding the relevance of several defense exhibits and was unable, according to the state, to obtain a response from defense counsel. So apparently there has been some objections to the defense's proposed exhibits on the grounds that it may be irrelevant to the case, and the state is alleging that they attempted to obtain some explanation, but apparently did not obtain at least appropriate explanation from defense counsel in the form of a response. Nevertheless, this continues. Consequently, the state has noted relevance objections to those exhibits, and in addition, the state is unclear which exhibits will be relied upon at the guilt phase versus the penalty phase. The state has noted objections to the exhibits being offered in the guilt phase. A word of explanation: if you go to the court's order, you will see that the court has, although bifurcated both phases of the proceedings into the guilt or the case in chief versus the penalty phase, the state therefore has noted their objections to the exhibits to the court being proffered in the guilt or the case in chief phase. State reserves the right to object to any of the listed exhibits if the exhibits are offered for another purpose than what was previously discussed with defense counsel in May 8th, 2025. What was discussed is a matter that is unknown at this time. This is signed by Ashley Jennings on behalf of the state of Idaho. We will continue to await to see if there is any notice of compliance with the court's May 15th order, similar to what the state, for instance, filed in Latah County on November 30th, 2023, when complying with an in-camera review ordered by then presiding jurist Judge John Judge concerning IGG evidence. Thank you for joining us today.